Welcome, everybody. And starting out by introducing ourselves, my name is Alan Friel. I am the chair of Squire Patton Boggs Global Data Practice, and I'm really pleased to welcome back my former and now again colleague, Lydia de la Torre. Lydia, would you just give the audience a little background on yourself?
Hi, Alan. It's a pleasure to be here and welcome to this webinar. My name is Lydia de la Torre. I am currently of counsel at Squire. I served for 3 years as a board member at the California agency. And prior to that, I have many experience in privacy, data governance, etc., both here in the US and back in Europe. I'm from Spain originally. I'm also the founding partner of a boutique law firm that's called Golden Data Law, and that's a very specific structure that I created because I'm a teacher and I was looking for an opportunity to create paths to privacy for deserving students, and that's something that I will continue to do together with my role at Squire.
And talk a little bit about your academic pursuits and some of the think tank work that you do.
Sure, happy to do that. So I teach comparative privacy, and I have taught last year AI and the law for the first time. I have been basically teaching all my life, but when I left PayPal a few years ago, I joined the Santa Clara University privacy program as the inaugural fellow. And that's when I really dedicated for several years most of my time to academia. And that was a pleasure. I collaborated with Eric Coleman on that. I think Santa Clara has an excellent privacy program today. And in terms of writings, I have been researching and publishing around privacy also for a while. There is a paper where I collaborated actually with Anne LaFrance, who was the former chair for Squire. And it's about GDPR and the EU AI Act and how those two things align and sometimes, unfortunately, don't align.
And your work with Future Privacy Forum?
Oh, yes, I was just recently appointed to the advisory board for a new center that they have created, and that's their AI center. I'm very excited about the work that center is getting organized to do, and it's just an excellent organization, the Future of Privacy Forum. So I'm very pleased that they reached out to me and asked me to collaborate with them.
So as much as we would love to have 100% of Lydia's time, she's a very busy person. But we're fortunate enough to be in the position to have a significant portion of her time, and she's already been very helpful with clients and assessing sort of what might regulators think about all these gray zones. And we're going to get into some of those gray zones today. So let's get right into it. All right. So what we're going to try to go over today, time permitting, and we want to leave time for questions because I know this is a unique opportunity. Let me just go ahead and say there are some things that Lydia cannot answer for what ought to be obvious reasons, but she is willing to entertain questions and answer the ones that she can. We're going to talk a little bit about the California and Colorado privacy regulatory systems, specifically the agency, the California agency for which she was on the board, its rulemaking authority and the current state of rulemaking and enforcement priorities. So moving on. Only California and Colorado so far have engaged in rulemaking under their consumer privacy laws, with these two states explicitly calling for regulations to be developed to develop the implementation details. We'll take a deep dive into the California process, But Lydia, how have California and Colorado worked together or not to collaborate? And why is there not more interoperability if that was, as has been reported, a mutual goal?
Well, California and Colorado, while both advancing their own consumer privacy laws and engaging in rulemaking, have largely worked independently, and each has been driven by their own specific regulatory priorities and timelines. So far, California, through the CCPA and its amendments under the CPRA, began establishing a detailed regulatory framework earlier than Colorado, which passed the Colorado Privacy Act only in 2021. I would say that the lack of deeper interoperability may be, to some extent, something that you can attribute to factors such as the differences in the regulatory structures, differences in timelines, and just also differences in governance models. Even though these structural differences exist, I do believe that interoperability remains a mutual goal. And I am very hopeful that additional steps will be taken to ensure that that is, in fact, the reality.
And we're going to, not to jump ahead too much, but we're going to talk about the economic impact of the current draft regs. And part of that is the differences between how Colorado has, being the first mover, set out the guidelines for things like risk assessments, and California being additive, not to be left behind. And we'll talk about sort of the policy issues related to that. But getting into the conversation, let's talk a little bit about how you've been involved from the earliest days in CCPA, CPRA, and give us a summary of that history. How did we get here, and where are your fingerprints on this?
Well, the California Consumer Privacy Act was enacted in 2018, as some of us remember. And it made California a pioneer in terms of robust privacy consumer rights. The law enactment, from my perspective, is the most significant privacy development in the US in decades. And it granted consumers new rights, such as access, delete, opt-out of the sale, which might have been the norm outside of the US, but we were not quite there. And I don't think that there was any hope that a federal law was going to be enacted to get the US to that level of responsibility around data governance from a regulatory perspective. What happened in 2020 is that CPRA, which was a ballot initiative, was approved, and that changed two things. One is it expanded CCPA with an eye towards adequacy, which is something that everybody who's familiar with Europe is familiar with, and that we all hope we will obtain for the US on a permanent basis. We do have a framework right now that ensures adequacy. It's being challenged. My hope is that we will survive that challenge, but still it was important for the proponents to make sure that California had a chance to adequacy if that was something that was needed. So that was one thing, increase the requirements to kind of align it with Europe. But then the second thing that happened is that because it was a ballot initiative, it became a set of requirements, principles, and rights that basically cannot be taken away from the California consumers absent preemption, absent a federal law that will eliminate the requirements in California, because the law in California states that when something is enacted through the ballot initiative, it can only change through the ballot initiative. There are some provisions in CPA, CPRA that state that actually Sacramento can modify CCPA, CPRA, but only to improve on rights for the consumer. So it really cannot be derogated, which is very, very important, and I think very different from what we will see in other states. That kind of I guess assurance for consumers that those rights are not going to go away. They're not going to be eroded through future legislative changes.
So one of the things the ballot initiative created was the California Privacy Protection Agency, something really unique for the United States. And you were on the inaugural board until just recently. In fact, I think you're getting an honor from the board next month for your service. Congratulations. But tell us a little bit about the CPPA. What is its purpose, and how does it differ from or overlap with the Attorney General? And what has it accomplished to date?
Okay, so yes, the agency is very unique. It doesn't exist in any other state. It's the first agency in the U.S. that is dedicated exclusively to privacy, and it actually connects with adequacy. Before CPRA was proposed, Alistair came to Santa Clara. We were having a conversation, and he asked me, "Can California be adequate?" And I said, "Sure, from a European perspective, you can do that, but there's some things that you're going to need." And number one in that list is you need an independent enforcer, and that's what the agency is. So the CPPA primary purpose is to enforce the provisions of the CCPA, as well as develop the regulations that might be needed to clarify and implement the law. It's different from the AG in that it's dedicated exclusively or primarily to privacy enforcement. There's a possibility that new laws might be enacted, and in fact, some laws have been enacted that make the agency the enforcer. But the AG has a very, very broad range of responsibilities that go way beyond privacy. And so even though the AG originally led the enforcement of the CCPA and will continue to enforce CCPA, their range is much broader, as I mentioned.
So we'll talk about the overlapping of enforcement and the differences between administrative and judicial actions later on. But let's turn to rulemaking, which is one of the agency's primary tasks. How does that work in California?
Rulemaking. And I was going to say this slide, I think that we created it with an image that comes from a prior board deck. So don't pay attention to the fall to 2019 reference there. It's not for this set of rules. It just refers to a prior set of rules, but everything else is accurate. So it's, I think, a very good graphic. It's the best graphical representation that I have seen of the process in California. So to answer your question, in California, the rulemaking process typically starts with the drafting of proposed regulations, often informed by public consultation and feedback from stakeholders. After that initial draft, the regulations are subject to a public comment period. That's the formal rulemaking process, which has not started yet for the new rules, but might after the next board meeting. And during this process, the agency gathers input from businesses, advocacy groups, and individuals, and fine-tunes the proposals. The agency may hold public hearings, and based on that feedback, it can revise the regulations. Once finalized, the regulations are submitted to the Office of Administrative Law for approval before they are officially adopted. And the board must vote to approve the rules at each one of these different stages that I just described.
So let's talk a little bit about the current status. The currently before the board are amendments to the rules that the AG promulgated back when it had the rulemaking authority, as well as completely new rules on ADM, automated decision-making, profiling, cyber security audits. Why is it taking so long And what's that process been like?
Sure, happy to answer that question. I will have to make a comment before answering that question, which is it's really slow. I mean, there are many controls within an agency, within any administrative body in California that slow things down to a level that I was not used to when I'm not against those controls, but de facto, it just is moving. What I'm trying to say is moving really fast, considering the page at which you can move as an agency in California. So to go back to your question, one of the reasons it has taken so long is the initial lack of resources, particularly in terms of personnel. When we created the agency, it was just us, the board, like 5 members. We didn't have staff. So that meant that we had to be strategic on how we allocated the few resources that we had, which we were lending or borrowing from other agencies. And then, the hiring process, which we knew will be, fast for an agency, but slow by the standards of maybe the private sector. So to address this, Chair Irvin and I worked on a strategy, and we created 2 separate rulemaking packages. And those are the packages that you just described. And we assigned them to 2 separate board subcommittees. I was assigned to the new rules subcommittee along with member Lee. Because of the staff limitations, I think very reasonably the board decided that we were going to prioritize updating the existing rules over developing new ones, because it was just more urgent for the regulated community to understand how this complexity of the new rules package. It requires careful balancing between protecting privacy rights and accommodating business interests, while ensuring the regulations are both enforceable and practical. There was, from the beginning, a design to align these new rules with national and international standards, such as those in Colorado and GDPR. We talked a little bit about that before. And that adds another layer of complexity, particularly since the new EU AI Act was just approved at the beginning of this year, while, basically our rules were already drafted when the EU AI Act was approved, and it was not clear to anybody that it was going to be approved. So that's another layer of complexity aligning with international frameworks. I think there's a potential challenge that the agency is going to face, and is that the agency, in particular the director, decided to move part of the package, the new rules package, outside of the subcommittee and present a draft that is basically an agency draft to the board. And the reason for that, as I understand it, was to expedite the process, which is a very good reason. But I do believe that this might have been strategically not the best choice, and I have expressed that in board meetings, because what that does is basically it deprives the draft of the opportunity of coming to the board with the full endorsement of 2 sitting board members. And that's going to make, I think, finding cohesiveness and hopefully unanimity within the board a little bit more challenging.
And there certainly has not been unanimity to date, right? You were one of 2 dissenters in a 3-2 vote to prepare the notice package. Why did you dissent, and do you think that your concerns will be addressed through the upcoming public comment review process? And what's that process like? Does the staff and the board really look at the public comments, or is this sort of a done deal?
So that's multiple questions. But let's start with the first one. So yes, I was one of the 2 votes that voted against moving forward the ADMT and the data protection impact assessment rules. I dissented primarily because I felt that certain provisions in the notice package lacked the clarity and will impose unnecessary burdens on businesses without enhancing consumer privacy in a meaningful way. My concerns revolve around the scope of the rules, which is something that Member McTaggart brought up. And to me, we should all listen when Member McTaggart says that the rules are out of scope. The practical enforcement of specific rules was another concern for me, and their alignment with existing frameworks, which I just think it takes more time. We should take the time to do that work before we move into the formal process. I am confident that the public comment process, if that's what the agency moves the package into next month, will help address some of the issues that were concerning to me. I think the feedback from a diverse set of stakeholders should highlight any unintended consequences or oversights and allow the board to make refinements on the draft. However, it remains to be seen if the final package will address the concerns that I had in mind when I voted against moving it forward. And that is also a key question for the board, how active they're going to be in terms of providing feedback to the agency and reshaping and improving on the draft.
And so procedurally, what happens is, assuming the board advances this to public comment, which in light of the economic impact report, maybe they will, maybe they won't, because that's new information that wasn't before the board last time when they moved to prepare the package. It's 45 days of public comment period, then review by the staff. What's the interaction between staff and the board between the period that public comments close and revisions are presented for a new public comment period?
Right. So that I think is a little bit left to the individual board member to decide. In my case, when the last package was approved, I had one-on-one calls with the staff to go over the rules in detail and ask my questions, and staff was very forthcoming in terms of explaining their reasons for the decisions that they had made in terms of the draft that they adopted. So that's available to any board member that wants to obtain that information, and the staff of the agency is very accessible and very professional in that sense. It's not mandatory. As a board member, you can choose to not engage in that kind of more detailed review. I mean, perhaps you want to do something more strategic. I really do not know exactly how the other board members dealt with obtaining the information that they needed to make their decision on what vote they were going to cast.
Great. So these are the elements of the rulemaking package, right? There's the proposed regs. There's the statement of reasons where the staff explains the reasoning for the rules. That will ultimately, there'll be a statement of reasons that address any revisions to those and why certain public comments were or were not taken into consideration. But there's this unique element, which is the standardized regulatory impact assessment. And from the date that the board voted to move forward a package, this is new, right? And I don't know if people have looked at it. I'd recommend that they do, but this is something that the agency itself has developed. It's not independent, correct? They hired an economist, but
yes,
it's not an independent agency of the state like the Office of Administrative Law is, right?
That's correct.
Okay, and so the agency's own expert, based on a preliminary assessment using conservative approaches, I'm quoting, by the way, here, this is from the agency's own report. Based on preliminary assessment using conservative approaches to assessment of the combined direct economic costs and benefits, The regulatory impacts of the new regs are estimated to exceed $4 billion in the first year of implementation. Does that surprise you?
It doesn't surprise me. I mean, that was one of the concerns that I had when I voted the way I voted. I think that 4 billion reflects the significant investment that it will be required by businesses to update their systems, train their personnel, and implement the new processes that will be needed to comply with the rules as they are drafted right now. And I also believe that it is correct to say that the first year is always the most challenging one for organizations, and that's where most of the costs will materialize. So I always expected the regulatory impact assessments to be high, especially for larger organizations with complex data ecosystems. It's going to be substantial. And this is why I insisted that the board should be presented with a SRIA before being asked to move the rules to formal process. I have been saying that in board meetings for several, I would say for a year now, because I think it's really important for the board to understand, right? This is a factor that has to be considered. And thanks to that insistence, I believe that this information is now available to the board before they make that decision of whether they move it to formal or maybe they take it back and reshape it before moving it to formal. And to be clear, these rules will be approved. I'm confident on that. It's just which version is going to go to formal and whether it makes sense to maybe refine the version before you move it to formal, or perhaps move it to formal and then you refine it while you're in the formal rulemaking process. So I anticipate that all of the members will review that assessment carefully and consider it carefully, and we will see what a decision is made by them in terms of the feedback that they will provide to the agency in the next board meeting, and ultimately how they are going to vote.
And one of the things that the report takes into consideration is the extent to which the California regulatory schemes for cybersecurity audits and data risk impact assessments overlaps with or differs from Colorado. So more overlap, less distinction, less cost. So that's something that certainly the board could look to address to reduce the overall cost. Also, these are just costs on California businesses. So the cost is going to be much higher when you take into account non-California businesses. And it's I think the number they assumed was $40,000 per business. I think most of our clients out there who've already been working to develop robust compliance programs would say that's a very conservative number. But just before we move on, I just want to throw out for the audience a couple other figures from the report. The agency reflects a loss of $50 billion in new investments into California, a loss of 98,000 full-time equivalent jobs, and a reduction to the state gross product of $27 billion. So these are big expenses. That's not to say from a public policy perspective, this isn't money well spent, but certainly there's a big public policy issue here that the board and maybe ultimately the legislature will need to revisit. But saving that for another day, let's move on and get a little further into the weeds. What is the Office of Administrative Law, and to what extent does it have authority over the agency when it comes to rulemaking?
Yeah, I'm happy to answer that question, but before I go into the question, I will mention, I mean, obviously it's not my responsibility right now to make that determination on whether this is a good policy to go ahead and spend the kind of resources that the SRIA describes. But if I were a sitting board member, I would definitely sit in that meeting expecting the agency to explain clearly the detailed reasons for what justifies the cost. And and consider whether there's a possibility where some of those provisions can be redrafted to perhaps reduce some of that cost. Again, it's the board that will decide. I think the next meeting is going to be a really interesting one. I will be there in person, and I think that people should tune in and listen to what the board says when this item comes up. Okay, so in terms of the role of the Office of Administrative Law, the review that they provide is primarily process-based. So they make sure that the process that the agency follows to enact the rules complies with the legal standards and procedural requirements here in California, which are many. Its role includes reviewing proposed regulations to confirm that they adhere to state law, evaluating whether they are necessary, and that's something that's justified within the rules, with the reasoning of the agency, ensuring that they are consistent with the statutory framework that establishes the power of the agency to issue rules, making sure that there's a level of clarity in the text of the rules and enforceability. So in all of that, the office facilitates also the participation of the public in the rulemaking by ensuring that these comment periods are open, that the agency took the time to read the comments and respond to them, etc. And to be clear, they do not consider the SREA itself. The content of the SREA is not something that the Office of Administrative Law is going to consider. They will evaluate the fact that the step has been followed. There's a requirement in California for that report to be generated, but they will not go into the policy decision of whether this is a cost that can be justified. So, in other words, if a SREA was needed but missing in the package, the Office of Administrative Law will not move the rule forward. They will not give approval. But so long as the report is there, whether the report says it's 4 billion or 6 or 1, that's not something that the Office of Administrative Law is gonna opine on.
And back when the AG had rulemaking authority, the OAL required some minor edits to the first set of rules where they thought the authority had been exceeded, but it wasn't a whole lot, right?
Right, but that's, that's because basically the staff of the agency is making sure that they comply before the Office of Administrative Law gets an opportunity to review it, right? There's a lot of work that goes into getting to a final decision when the office says you're good or you have just minimal edits. So one of the features of the rules that everybody who has read the rules is familiar with is the examples. There are so many examples in our rules, and the staff is including those examples for clarity so that when this goes to the Office of Administrative Law, they don't come back to the agency and say, hey, this is not clear enough. So there's many other things that the staff is doing. I guess what I'm trying to say is that the fact that they're having very few requests from the office speaks just to the quality of the staff that the agency has and how thorough and thoughtful they are when they're putting these packages together.
I know taking us off script for a moment, but let's talk a little bit about the staff, because this is an agency that did not exist until the ballot initiative, and so it had to start from scratch. It had 0 employees. Well, what does the staff of the agency look like today?
I don't actually have the latest numbers, and I don't feel that it would be appropriate for me to share the numbers that I'm familiar with if they have not been made public by the agency. But I will say that the agency has done a really excellent job at not only hiring fast for California standards in terms of how fast you can hire, but also hiring quality staff. The staff of the agency is really dedicated, professional, prepared, etc. So I'm really proud of having been part of that, and I'm very confident that they will continue to do the same. They will continue to attract really awesome talent and hire. I will share that, one of the areas where this agency is being strengthened and that will continue into the future is enforcement, because once we are done with this rulemaking initial effort, where the agency is going to be is basically in enforcement.
And we're going to get into enforcement in a little bit. I'm going to pick your brain about enforcement priorities, but let's dig in the weeds a little bit about the new regs. So you were on the board when the amendments to the existing regs were developed, and on several subcommittees, including for the draft of ADM and cyber audit rules. What's that process been like? What's the sort of substance and goal of these new regs? And what's sort of the staff board dynamic? I know that, again, 3 questions enrolled into one for you.
Well, the process within this subcommittee has been both thorough and collaborative. That's my experience based on the subcommittees I've been a member of. And it has served as a vital platform for building trust and fostering cooperation between the board and the staff and between board members. I have been a proponent and I have supported for a very long time the creation of subcommittees and maintaining subcommittees for that reason. The subcommittees have facilitated extensive discussions. They have allowed members to engage in meaningful interactions with each other and with various stakeholders. They have brought experts. We will bring experts into our subcommittee and talk with them in a more informal way than what can be done during a board meeting, gathering diverse perspectives, ensure that all voices are heard. So this collaborative approach, like I mentioned, not only strengthens the regulatory framework that comes out of subcommittees, but also enhances the overall credibility and effectiveness of the board work. I think the trust built within these subcommittees is essential for moving forward as a unified board, and I really hope that the agency continues to maintain subcommittees where it's relevant and helpful.
And in what ways do these draft regs overlap with or depart from the existing Colorado regs, and what's the thought process been about that?
Well, the existing regulations in California share many similarities with the Colorado privacy regulations, particularly regarding consumer rights, such as access, deletion, opt-out, mechanisms, etc. And I think both frameworks emphasize transparency and consumer control over personal data. That said, if the draft of the new rules that exist today moves to formal and it's approved, the obligations in California will significantly be more stringent than in Colorado, particularly as it relates to security, data protection impact assessments, and also automated decision making. I do believe that California regulations will always tend to be more comprehensive and stricter than regulations in other states. And I also do believe that California will likely be much more active in enforcement than other states because the resources are there for the agency and for the AG to actually engage in enforcement.
So there's a lot in these draft regs to unpack. A new concept of behavioral advertising, regulation of use of personal information to train AI, monitoring of employees and public places that depart from the sort of Colorado framework. And a lot of our clients are concerned about this, and there's a lot of public policy issues here. Does filing public comments really make a difference? Should companies that are concerned about the direction of the regs be considering filing public comments, and what's the board's role in reining in staff or really directing where the policy is going?
So I can answer it affirmative to that. Yes, the public comments are important. They're given due consideration and they are carefully evaluated both by the board and I think by the staff. I personally dedicated hours of my time to reading comments, particularly at the beginning, because we didn't have the ability to have staff summarize the comments, which I expect is what is going to happen moving forward. That the board will be presented with some form of summary of the comments file, as opposed to having to read the actual comments. And to me, that engagement provided very valuable insights into the perspectives of different stakeholders. From the point of view of the board, we're all, we represent policy within the structure of the agency, and as we're independent individuals, but we do have appointing authorities that have their own, perspectives from a policy point of view. So each board member has the choice of, how much do they engage in terms of, reading comments. I don't think that other members read as many comments as I read. I can say that much, but I know that all members take it seriously, and they will find their own way to obtain the information that they need to make a responsible decision regarding their vote. So what I would say in terms of comments is that if you're filing comments, which you should think about how you are effective in terms of the comments that you file. So being specific is one thing that I will advise. Don't find something that's general, because we probably are going to read that, many times, because there's so many people filing. So something that's specific is helpful. Providing evidence is helpful. Suggesting alternatives is also very helpful when you're reading those comments. Expressing how the rules impact your organization individually, I think is also very powerful. And also engaging with other stakeholders, and that is, there are groups, industry groups that collaborate in terms of presenting, filing comments that are, structured to address the concerns of the group. I think that's also very valuable. If individuals, companies, and groups follow those principles, the comments can significantly affect the final version of the rules. And this is not only, I know that, our audience is mainly companies, but individuals also file comments, which I think is great, right? Like as an individual resident in California, you can file a comment explaining to the agency how you will hope that they will draft a final rule to make sure that you are protected.
And let's talk about the audience for these comments. Obviously, there's the staff. Those are the full-time professionals that are the subject matter experts that are doing the heavy lifting with respect to the rulemaking. And then the board, those are the policy makers. How is the board comprised? There's different appointments, and so the different board members sort of reflect different policy constituencies. Can you explain sort of, how the board is comprised? And
yeah, so there's 5 members. One is appointed by the Senate. That was me, and now we have a new appointee from the Senate, who's great. He's gonna do far better than me. He's fantastic. And then we have an appointee from the Assembly, an appointee from the AG, and 2 appointees from the governor's office. And basically, we represent all of these different institutions in California within the board. We are independent. Our appointing authorities do not tell us, how to vote. But in the selection process, the appointing authorities, I assume, have in mind what is it that they are looking for in terms of who they want to represent them in an agency that, to me, is critical for responsible data governance in the state. So there's, all of these main legislative enforcement bodies are representing through us on the board. And you're absolutely right that the role of the board should be a policy role. It's not like the FTC, where the commissioners are full-time employees of the FTC. Board members for the agency are just paid per diem, so we're not supposed to be there every day, working. Although I will say that did happen at the beginning, and I say member Urban, for example, you see the effort that she put in to get the agency moving in the first year was amazing, and just speaks to her dedication to public service. But now that we do have staff, I think that there has to be a balance that has to be found between the staff filtering all of these comments, generating objective summaries, and the board members having access to those and just deciding where they want to vote based on their own beliefs and their own experiences.
And what's the sort of the interplay or interaction with the governor's office? I think Member McTaggart was pretty vocal in prior meetings that the ADM rulemaking is overlapping with AI policy,
right?
That may or may not be consistent with where the state's headed otherwise. What's that dynamic been like?
I think that comment actually came from me, and Member McTaggart repeated it, or I don't know who in between the two of us, but that's something that is concerning to me, right? That if we are moving as an agency in one direction, that we also have to think about what Sacramento is doing, what the governor's office is doing, so that we can be cohesive as a state. And I mean, there's no obligation for the agency to do so, but I think it's very wise to be respectful and also being mindful of the fact that this agency was created by ballot initiative. The people who voted to create the agency were allocating a number of resources, financial resources to the agency with the intent that those resources will be used for a particular use, which was really privacy. And if we go beyond that in terms of rulemaking, we're deviating those resources from where the voters, in my opinion, wanted them to potentially other areas that might not be proper for the agency to take over. There's always the possibility Sacramento could enact a new law that regulates AI and appoint the agency to enforce it and give a budget for that responsibility. And I think that when you're thinking about scope, in particular, from my perspective, and I think my Member McTaggart perspective, when there are questions about whether we're going beyond the scope, a much wiser approach is to just not go beyond the scope and have a conversation with the legislature and say, hey, there's something that is needed that is not within our scope. We are hoping that you will enact a law that addresses that and trust be the right enforcer for that new law. So there's different paths to get to the same outcome, and I don't know that all board members see it the same way. I can share how I was seeing it at the time when I was a member and really now, and we will, I think, learn a lot about the perspectives of the different board members on that point in the next board meeting.
Yeah, it's going to be an interesting meeting for sure. Let's move to enforcement. Let's start with the dual enforcement roles of the AG and the agency, and how that process differs as between them.
So the AG and the California Privacy Protection Agency both play crucial but distinct roles in enforcing California privacy laws. When you think about the AG, as I mentioned before, they are responsible for enforcing the CCPA, but also can bring actions against businesses for violations of many other laws, including unfair and deceptive acts and practices, which is something that has been used for many decades in this country to enforce privacy. That's not something that the agency can do. The AG process is also a little different. It involves issuing notices of violations and sending those out. I am assuming that some of the people who are watching this webinar have received notices from the AG. And one thing that needs to be highlighted in that regard is that allowing a right to cure is no longer a legal requirement for the AG. They can choose to notify you and give you time to cure, but they don't have to. So the AG process is going to be different from the agency process. And the agency is only dedicated to privacy, and particularly the provisions of the CCPA, and the enforcement actions will be administrative. So they are going to go through the administrative enforcement process. In California, and ultimately the board is going to have to vote to approve any decision that is made by the agency in terms of enforcement. So it will come back to the board for vote, although the board will not participate in the enforcement. That's going to be driven by the agency. There was a presentation that was provided by the general counsel of the agency a few meetings ago that I thought explained really clearly what is going to be that dynamic between the board and the agency. And the agency has created internally, different offices to deal with the complexities of enforcing under the California Administrative Procedure.
And this slide I've put on a sort of a comparison of settlement amounts over the last several years related to privacy actions that the AG's office has taken. So you can see that the CCPA settlement civil penalty amounts are relatively modest, not insignificant, but modest. But at the same time, the amounts where matters were brought under the UDAP, the consumer protection laws, pretty significant. Do you foresee the repercussions of CCPA actions increasing now that companies have had an opportunity to set up their compliance programs?
Right. So to me, the limited number of published resolutions and civil penalties suggest that the regulatory agencies are looking into enhancing compliance and remediation rather than jumping immediately into penalties. To me, that's the right approach. I am glad that that's the approach that has been followed. And particularly when we're talking about enforcing rules and regulations that are really new to our state. And I do believe that you're right in terms of what should be projected towards the future. We should expect that the potential for higher penalties is ahead. Anybody that understands how penalties are assessed under CCPA knows that the agency and the AG could have chosen to impose much higher penalties in any of the cases that has been published. And I do believe that they will increase over time. That's what makes sense. The dynamic of how you engage in a conversation with an agency here in California is not different from the dynamic that organizations follow in other jurisdictions. So being proactive, being able to show that you're being responsible, that you're trying to do the right thing, is going to go a long way in terms of landing you in the space where you're maybe let go without a penalty, or you're assessed a low penalty versus, you're given a much higher penalty that you have to deal with as an organization. So I will advise organizations to start investing now, thinking about that, because the enforcement that we will see 2 years out is going to be for things that are happening right now. So you have to think about it right now, when you see the enforcement come out.
And we've got 3 public settlements to look to, but the AG has published summaries of the multitude of inquiries that it resolved at its discretion without a civil penalty, without a public settlement agreement, and those are good signposts for companies to look at what's important to the regulators. And where they need to be addressing their attention. But at the same time, the agency is developing its own enforcement priorities, and the staff has presented basically an enforcement roadmap to the board. What are some of those priorities, and where do you think companies ought to be putting their attention to keep from being one of the next brands that's up on this slide when we do this same presentation a year from now?
Well, let me start by saying that I think setting priorities for enforcement is a policy question, and that the board should be active in identifying what they believe should be the priority for enforcement. We're young I'm not there anymore, but the agency is a young agency, and some of these processes, they will be refined with time. So my expectation is that we will see the agency propose ideas for priorities, and the board come back and refine them in future iterations of these. I don't believe that you were wrong in pointing out the resources from the AG as a very important host to look at if you're an organization or have your outside counsel advise you about. The one thing that I will highlight that has come up in recent enforcement, and I think will continue to be a challenge for organizations, is that those integrations, like the SDKs, the integrations of somebody else's technology into your processes, and how diligent you have to be about making sure that you understand what that technology is doing with the data that you're responsible for. And just the movement towards, we're moving away from, we're enforcing because your privacy notice says X and you did Y, to actually, what are you doing? Like we now have staff that is technical, that understands where data is coming in, where data is going out, and we want to see that is done appropriately. So moving towards investing more in that space of data governance from a technical perspective is something that I would definitely advise organizations to do, because I see the agency staffing to be able to do that kind of analysis. The AG is also thinking, I believe, in that direction. And that's where companies should be. Make sure that you do what you say you do.
And we've seen enforcement actions, not just from California, but Texas, most recently Oregon. What's the cooperation between the different states? Are we going to start seeing multi-state enforcement actions like we do with consumer protection laws in the privacy space?
Well, I heard this question being asked of Stacy Cheshire, who is the head of enforcement for the AG, multiple times, and she always gives the same answer, which is, of course, you should expect collaboration. And I'm not surprised, and we should not be surprised about that. We have seen AGs across this country collaborate on enforcement. When there's a data breach, the process is there, they know each other, and it's a smart thing to do as an enforcer. The resources are also limited, so collaboration ensures that they can actually do more with less by relying on other agencies that are in different states that can kind of help move the ball forward, while they maybe take more of a backseat approach in some enforcement actions and lead others. We haven't seen that materialize yet, but I do expect that that's in the future, yes.
Great. Well, I don't see any questions in the chat, but I'm going to invite the participants to put questions into the chat. We've got, I think, a minute left. So if anyone has a question for Lydia, please put it into the chat. And I don't.
You've been so good in drafting your questions, Alan, that there are no more questions.
Yeah. All right. Well, I will pose a final question to you, Lydia. What you got any takeaways? What from your seat? What should companies really be doing or thinking about or concerned about? What should keep the general counsels up at night when it comes to data privacy issues?
So there are many, but I will highlight collaboration inside the organization, collaboration of the different teams that are dealing with data, and in particular, transparency, so that your legal team actually understands what's happening with the data. That kind of communication sometimes is not easy. It might require you to create some form of data governance team that brings together your compliance people, your legal people, your IT people, so that they can have that conversation. And this connects with what I mentioned just a moment ago, which is that we're likely to see more enforcements that actually are looking at what is happening with the data. And it's important for your legal team and compliance team to be able to address that risk, to actually understand in detail what's happening with the data.
So Lydia, thank you for your time. Thank you for your insights. For the audience, couple QR codes here. We'll send out the presentation so that everyone has them. You can subscribe to our AI Hub and our Privacy World blog, which I'm happy to say is the most visited of all the firm's online resources. And for people looking for CLE, add the code DATA 1017, and you will get a certificate for the CLE credit. Any issues, email Rob, and her email is here. And you can also get IAPP credit. Just go onto the IAPP website and self-report that you had an hour of privacy training through Square Patent Boggs. So thank you, everybody, and have a good day.